It seems Supreme Court justices have at least one billionaire that they ride around on jets with, and they never pay no fare. Then they make decisions favoring the guy who paid the bill. They don't have to follow rules, and they probably never will.
Welcome to Legal Considerations with Judy Donegan. My name is Paul Thomas, and I'm the host of this evening's discussion. Since Trump and McConnell managed to stack the Supreme Court with radical ideologues, there has emerged some new and very concerning developments that warrant scrutiny and analysis. Here to discuss these issues is my go-to lady when it comes to anything legal, Judy Donegan. Welcome, Judy.
Thank you. Hello.
Okay, thanks for agreeing to do this.
I was a little reluctant, you know.
Well, it took some convincing, but you came on board. I appreciate that. The first item we need to address is what came to be known as the Major Questions Doctrine. I'm not sure if it was first created by Gorsuch, Kavanaugh, or Roberts, but since its inception into the dialogue, all the Republican appointees have relied on it when they needed a reason to undermine the administrative state. Here is my understanding of how it works. When Congress passes a law designed to protect the population, such as the Clean Air and Clean Water Acts, they assign language the authority of specifying the regulatory details to the federal agency, like the EPA, to write and enforce those regulations required to keep the water and air clean for consumption. The law passed does not include all the specific details because Congress does not have the expertise or foresight to identify any and every circumstance that may require intervention. The experts are the people who work at the EPA, and their authority to write and enforce needed regulations was granted by Congress in the law. Now come the polluters and their lawyers with the claim that the administrative state has no authority to enforce anything not specifically addressed or defined in the legislative text, like whether a puddle qualifies as a body of water. My understanding of the Major Questions Doctrine is that if the specificity is not spelled out totally by the legislation, the federal administration is not equipped to provide the required expertise. The only true authority with the necessary background and experience to know what to do are the 9 black-robed environmental experts on the Supreme Court. Did I get the gist? What is your understanding, Judy, of the Major Questions Doctrine?
I think pretty much you have the gist. I want to say just at the beginning there that while I did work for years in the federal courts, I am a lawyer, it's been 15 years. And as we know, as you just pointed out, a lot has changed. So I'll do my best here. But I have
okay. Before I let you go on, when you say it's been 15 years, the new people that showed up on the court have brought all this stuff on. This
That's
Major
right.
Questions Doctrine is something that you weren't aware of because it really didn't exist during your time working in the legal field. Is that correct?
That is correct. And very much has changed. And, you know, I think as I express when I talk to you, very often I'm really stunned and surprised by what is going on. But then I can get cynical too. So is it cynical to suggest that the recent decisions of this court and the grants of cert, that is the cases they're willing to take, seem designed to benefit industry, like coal mines or manufacturers or whatever? And is it too glib to say that Christian nationalism is alive and well on the court, so that we're heading toward a Christian, male, usually wealthy patriarchy, which makes me wonder how any women can support what's going on. But let's go back to your question. Major questions doctrine. I think Roberts wrote the majority opinion. I'm not sure he's the force behind it. But it's, I think that what it will cause is a lack of regulation. That is, if agencies are not allowed to write regulations or to enforce compliance with, say, the Clean Power Plan, which was the subject of the West Virginia case. So if we go back, the Biden administration proposed a Clean Power Plan, which would be a step down. So power would be from coal, and then you'd step down to natural gas and step down to renewable energy. That plan never went into effect, but that didn't stop the court from deciding a case saying that, I don't know what they said about the plan, but that led them into the major question doctrine that agencies, it is not proper for agencies to be making these decisions on what they view as major questions. And of course, what a major question is whatever they think it is. So,
but a major question is something, whatever they think it is, regarding the federal administration of anything, right?
I'm sorry. Well, yeah.
The federal administration of anything leads to a major question, which is what they think should be questioned.
Well, but you can get, when you have these sort of broad statements like major question doctrine, which nobody knows what that's supposed to be, it can be defined however they want. So let's suppose there's a regulation that they like. Can't think of one, but perhaps.
Neither can I.
Well, there might be. I mean, there might be a regulation regarding welfare payments, for instance.
Okay.
Are they gonna like that regulation? And if they do, does that become not a major question, but something that actually the department can regulate?
So are you, I'm gleaning this from what you just said, is that the major question doctrine comes into effect whenever it is something that is in ideological alignment or ideologically opposing what their ideology is.
That is exactly what I'm saying.
Okay, yeah, okay. I agree with that.
I mean, it's pretty cynical view, but
the evidence is there, right? That's what they're actually doing all throughout the major questions. Every time they bring it up, that's pretty much what they're trying to do.
Well, and then when they go out of their way to decide a case about the Clean Power Plan that is not in effect, that's an advisory opinion. In my day, to sound like an old woman, advisory opinions were not issued. There had to be, under the Constitution, a case or controversy. There has to be an actual conflict between the parties before you decide a case, before anyone's allowed to litigate a case. So we don't have regulations in effect under the Clean Power Plan. Why are we dealing with it at all?
Yeah, why stop something that hasn't started?
Exactly.
Yeah, and I think that's pretty much the case with the last question about the Colorado suit with the gay wedding planner, or was it? Yeah, the wedding website. Yeah.
Yeah. That's
okay. Moving ahead, because our producers only give us a limited amount of time here.
Okay. I'm sorry.
No, that's good. Unless you have anything more to add about major questions, I think we pretty much nailed what it's about.
Yeah, and related to that, I'll just say that the Chevron doctrine, where the courts gave deference to agencies if their interpretations were reasonable is about to bite the dust too, I think. There is a
Right.
case pending now. Okay.
Yeah, the judicial people who study the judiciary are all in concluding that it's gone. The Chevron is about ready to go to the wayside. Okay, the next brand new phrase they just made up is historical analog. This came up big time in the New York State Rifle and Pistol Association v. Bruin. Remember that word, Bruin, now. That was the case when SCOTUS declared that a century-old New York state law requiring permits to carry handguns unconstitutional because the historical tradition didn't support the requirement. Not that being a law for over a century qualifies as a tradition, but every other instance of restrictions of public carrying handguns for 2 full centuries on the books across America and unchallenged until now was declared irrelevant by Clarence Thomas, who wrote the majority opinion. This 6-3 decision opened the floodgates to the most egregious suit, United States v. Rahimi, where Zach Rahimi, a documented domestic abuser, a convicted felon who did time for his crimes, recently arrested for shooting his handgun off at a commercial strip mall, who has a legally authorized restraining order prohibiting contact with his ex, that Rahimi, filed suit in a Texas federal court claiming that the federal law prohibiting documented domestic abusers from owning a handgun was unconstitutional. This case made it all the way to the Supreme Court with the argument that the historical analog could not show that the writers of the Second Amendment in 1791 even knew that domestic violence actually existed. Since they didn't know there was such a thing as domestic violence in 1791, any law passed considering something the framers didn't consider did not pass the Bruin test established by that decision. I listened to the entire oral argument, and I was not surprised to hear Alito and Thomas trying to worm their way into justification that this maniac Rahimi should be allowed to keep his guns. Does this historical analog referencing really amount to ideological cherry picking, which makes the 6-3 rulings a vehicle for destabilizing our 20th century society, or am I overreacting again? Judy, I don't know how familiar you are with Rahimi, but when I listened to those oral arguments, I was just angry that they would justify having this crazy guy who had a restraining order against him. He should keep his guns, because the Second Amendment says that you have to. And they didn't even think that, domestic violence in 1791 existed, so we can't count it now.
What they thought was there was a right to domestic violence. And they also didn't have assault weapons in those days. So it is, it's hypocritical. I think that's one of the main criticisms of the court at the moment. Conservatives always used to complain about the Warren Court as being activist judges. And now we have this. And if this isn't activism, what is it? But what it really is I think, is just a philosophy based on a search for preferred options. It's like, what is the answer we want to get to, and how do we get there? And well, that I suppose isn't always a bad thing. Though on the Rahimi thing, I have read the decision, and actually when I was working in the court long ago, there was a dissent to a domestic violence, to this same statute, which is 922G. I think
it's a federal statute, right?
Right. So there's a whole statute with a lot of prohibitions on gun ownership, felons, domestic abusers, so on.
Mhm.
But way back then, there was a judge who actually I knew pretty well before she became a judge, who thought that it did not apply. It was a dissent, fortunately, but that uh, the statute didn't apply to, should not, was not constitutional, I guess is what we'd say. So, but I read that the Giffords organization, the gun control group, um, claims that in cases, Rahimi is horrible. And it's the one that gets all the attention. And there are others that get similar attention. But Gifford says that 88% of gun regulations are still being upheld. Now, I don't know if that's true, if people are finding a way around this, or what, but that 42% of the ones that are not upheld are by Trump-appointed judges. So I think your ideological reference is apt.
I think a lot of times the regulations, especially in the red state legislatures, are being eroded away by legislation. Like in Florida, you're allowed to carry handguns, and you know permitless carry handguns in Florida, and that was something that came out of DeSantis's um, rubber stamped legislation. Even after Parkland. They just they had something when Scott was governor, but then they brought it all back to where they could walk around permitless carry handguns down in Florida.
Of
So
course,
yeah,
they're only the good guys with guns.
right, yeah. But yeah, that as far as the historical analog issue, it seems like Alito and Thomas just rely on that. You know, they even just said in the oral arguments, or no, in the Section 3 of the 14th Amendment, uh, brief or not the brief, the decision they came out with, they said that there was no precedent for the enforcement of Section 3 of the 14th Amendment. Of course, there was no precedent because
Of
no
course
one ever
not.
tried to overturn an election as a president. So, that it's just so frustrating for me to see how they're able to just justify any ridiculous notion because they want to achieve their ideological end.
Yep. Preferred outcomes. That's what we want.
Yeah, that's a good phrase, preferred outcomes. Okay, on to Section 3 of the 14th Amendment. It's been all the buzz recently, but Judy, I have been chewing your ear off over this for years. So I'm
For
going to read the
years.
whole text. Yes, for as long as I think ever since the insurrection, I've been talking about it. I'm going to read the article, the whole text before we jump into the weeds, so our viewers can see clearly exactly what it says. So here it goes. Section 3 of the 14th Amendment. Quote, no person shall be a senator or representative in Congress or an elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, in support of the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability. Unquote. There is a claim by a few of the justices that are strict textualists, meaning their decisions on cases are based on the actual text of the Constitution or statute, and referring back to the historical analog reasoning, what the framers meant when the text was written, Section 3 could not be expressed in plainer English. On a 9-0 decision, the court said that a single state, Colorado, in this filing, does not have the authority to restrict ballot access for a federal election. they, and I'm guessing Roberts, I may be wrong, but my guess is Roberts, went further to say that Congress needs to weigh in as to how disqualification is determined. Kagan, Sotomayor, and Jackson wrote a blistering concurrence. I don't know why they call it a concurrence, but it was it was an objection where they chastised the per curiam writer for going into the weeds with a description of how it should be done. Before I get into my idea of what door they opened, tell me what you think of the opinion overall.
Oh, well, I agree with you. I think it was probably Roberts that wrote it,
Okay.
because during the oral argument, uh, during the oral argument, he raised the issue that the 14th Amendment generally restricts the power of the states. So why would Section 3 give power to the states to do this? So I think that was his idea. And I heard someone say that the concurrence by the three justices was actually originally labeled a dissent. It would probably be concurring in part and dissenting in part, because they did go along with the bottom line.
That a single state could not enforce a federal
Yeah,
constitution. Okay.
that the whole 14th Amendment restricts state authority, business and federal primacy, and so on. They went along with that, but even Justice Barrett in her concurrence, very short, agreed that the court had gone too far in telling Congress not only that they had to enact a statute to, that this wasn't self-effectuating, apparently, which I think I said to you a long time ago, Paul. But anyhow, that they told Congress how the statute had to be written and what it had to be saying, and when do they do that? So that was one of the big objections that the four women on the court had to the decision. I think it's pretty sloppy, but on the other hand, I think that this issue is way more complicated than you think it is. And I think that there's something wrong with almost whatever you say about this case, how it should come out. I'm all over the map on this. So,
Okay, here's what when this came out, I read the whole thing and I couldn't sleep at night because I came up with this idea that what happened in the impeachment of Trump over this, the articles of impeachment said that he was being impeached for inciting an insurrection. So that's right there in the articles of impeachment. The House voted to impeach, okay? And the Senate, a majority of the Senate voted to convict, okay? Now, the Constitution says that in order to remove from office, that you need 2/3. But I feel that their claim that Congress needed to act did occur. Congress acted when they impeached him, and the majority of the Senate agreed with the House that he violated the 14th Amendment by inciting an insurrection. So in my mind, their claim that Congress needs to weigh in on it has already taken place. Now, the 2/3 didn't occur, which would have removed from office. I agree with that disqualification part, but no, I'm sorry. The removal from office part, which would require the 2/3. But the use of the 14th Amendment, which is also stated right there in the Articles of Impeachment, Section 3 of the 14th Amendment, was approved by both the Senate and the House with majority votes. So what I did was the next day I called Jamie Raskin's office and I talked to a very nice lady who answered the phone. And we talked for about 5 minutes where I explained this to her. And I said, what Jamie Raskin needs to do, because he was an impeachment manager, he needs to file suit in federal court, because that's not a state, That's a federal court saying that he needs to, that this court needs to enforce the 14th Amendment because Congress did their job. Now, he would have standing, being an impeachment manager, to file that suit. Now, would it be the Supreme Court trying to wiggle their way out of it? Sure. But at least you put it back in their face and say, look, you sons of bitches, you put this out and you said that Congress needed to do this. Congress did it. He was impeached for the insurrection. Right there in the articles of impeachment, it said insurrection. It also said Section 3 of the 14th Amendment. The House impeached by majority vote. The Senate gave a majority vote. He should be disqualified. We did our job. Now you do yours.
But they didn't ultimately do their job. They should have convicted him in the Senate. It's, you know, a couple things here. I read a column by Charlie Sykes, who, by the way, is someone I used to know, who in the Washington Post, who said that Trump's the luckiest person alive. And he goes through all the things, all the little, not little, all the huge things that he got out of somehow. And, you know, 2 impeachments, he did not get convicted. It's funny you mentioned Jamie Raskin, because just before this started, I got an email, fundraising email, I think, but anyhow, no doubt.
I'll bet you get a lot of those.
I get thousands. What can I say? But Jamie Raskin now is apparently urging Congress to pass enabling legislation for this. So maybe that's the first step in their response to you. I don't know, but maybe you got his attention, Paul. What can I say?
Well,
Although
no,
the guy is pretty on top of things.
Yeah, I told that girl I talked to on the phone that there's no way Mike Johnson is going to let this go to the floor.
Never.
You know, I mean, Jamie Raskin might think he can put up legislation, but you got to get it to a floor. And if you're going to get a discharge position, you need some Republicans that are going to vote along. And Trump owns every Republican in that Congress, every single one of them. So I think he should just start off with filing your suit in federal court and go from there. But that's my pie in the sky.
You know, you've taken care of 2 of the issues that the court raised here. One is if it's in federal court, then we have and if it's a federal officer bringing suit, we don't have the problem of the state. And the other issue is, I like your idea that the impeachment articles of impeachment that mention insurrection and vote for the articles of impeachment that includes that he was an insurrectionist, maybe takes care of the problem of, you know, who proves insurrection and what's the standard of proof? And there are a lot of questions, you know. The Colorado case was a week long. They relied on the House, the committee report. I forgot what we call the committee. And but they did investigate, you know, is this an insurrection, which is one of the big questions. And not that we think Trump wasn't an insurrectionist. And by the way, in the questions I raised, I don't think anyone is more frightened about Trump winning this election than I am. It's horrible. We don't even have words to describe that man, just like we don't have previous examples of cases brought under this statute. We don't even have language to describe what he is. So that's one thing. I think that, you know, as far as who can bring this suit, the court does mention that the electors clause and so on gives power to the states to control some, you know, who goes on their ballot as far as age and so on. And their way of disposing of that, for instance, let me read. They say there is little reason to think that these clauses implicitly authorize the states to enforce Section 3 against federal office holders.
Which is
Is
bullshit.
that a reason? I mean, is that a reason is my question. That's
Yeah.
not a reason, that's a generalization. But
Because they enforce other qualifications, age, where you were born.
well, they also the states enact voting rights, voting requirements, voter ID, and so on. And so then we get to the next thing about the patchwork. I'm criticizing all this. Part of it I kind of agree with. And the patchwork thing is convincing at first glance. You know, you don't want every blue state, maybe you do, but whatever, every blue state removing Trump from the ballot and every red state keeping him on. You have this sort of patchwork going on, which is a little troublesome. But we also have a patchwork of voting requirements. So picture IDs or whatever, you know, that states have enacted. So there is just a lot, there's a problem in that, I think in Section 3, but there is definitely a problem in the decision.
Well, federalism itself, which gives states some authorities and gives the federal government other authorities, is a patchwork destined for chaos, which is what we really have right now. With the voting restrictions, the gerrymandering, all that has been chaotic. And the patchwork exists. They're not saying that this is going to create a patchwork. The patchwork is there. It's all over the place. It's in every state. You have ranked choice voting in Alaska. You don't have ranked choice in other places.
We so far have ranked choice voting. It's going to be on the ballot to repeal it. Well, probably going to be on the ballot to repeal it. Conservatives don't like ranked choice voting. So, yeah, I mean, it's almost this. I told you I was hoping I could gather my scattered thoughts. I almost can't. I mean, I would like a lot of steps a lot further back, like impeachments and Trump's. Republicans should have been standing up to him. And what on earth is Mitch McConnell doing? And so there are steps along the way where this should have been taken care of, and it wasn't. And I'm terrified at the prospect. But I was also a little concerned about whether a state should be doing this. I mean, it seems more important than a lot of issues. Oh, and also I was going to mention, as you were reading, I'm sorry, it's not going on too long.
No. Go on. See, Mike said you're allowed to talk. It's me he wants to restrict.
Is Mike going to shut off my mic?
No, he's going to restrict my mic, not yours.
So, when you look at the officers that are named in here, even Justice Jackson had a little problem with the president not being named in this thing. And of course, he is an officer of the United States, but one of the things that's a little bit convincing is when the court says that the president is elected by the whole country.
Right.
And state officers are elected by the state. And even senators and representatives, while they're federal officers, are elected within the state. So it looks to me like, I haven't looked at this closely enough, but it looks to me like everybody mentioned is basically a person elected by state voters rather than national voters. And of course, then we come to
there are only two people.
Yeah, right.
President, vice president.
Right. So, and of course, then it does mention the electors. I mean, when you say that the president and vice president are elected by the whole country, well, they're elected by the Electoral College. But anyhow,
Hey, I can go along with the fact that a single state should not be having the authority to do that. But what I say to that is the Supreme Court, do your job. Do your damn job. The 14th Amendment says insurrectionists are not supposed to be qualified to run again. So you should have stated, okay, Colorado does not have the authority to do that, but we, the Supreme Court, has the authority. That son's a bitch is an insurrectionist. He needs to be kicked off. And all I'm saying is the Congress already did their job, and they need to put that in front of the court, not something that came out of Colorado, something that
Well, and
came out of Washington D.C.
they maybe do need to put some, it's not going to get there. We're going to talk about immunity.
Oh yeah, that's the very next question.
Okay, well, I'll be quiet then.
I'll get to it right now then. Where am I? Okay. They recently took up the case of Trump's presidential immunity from inciting an insurrection and stealing classified documents. How confident are you that SCOTUS will find that we are not a monarchy and the criminals who commit crimes must stand trial when they are caught? How confident are you, Judy?
Well, let's go back to how confident am I that they'll make a decision in time, even if they declare he doesn't have immunity. I am not, well, I think they have to find that immunity does not exist for some actions. One
Do
possible,
you really believe that?
I do kind of,
Given
well, I don't see, okay, maybe I'm naive, but how can you, I am sorry, my phone is ringing. But okay.
Okay,
Can I edit this?
given their historical decision making, and I'm talking about Alito, Thomas, Gorsuch, Kavanaugh. I'm not even putting Barrett in that because I'm developing way more respect for her than I had initially. But I'm not sure they're going to say he's not immune. I'm not sure they might not just come up with something. I talked to my son about this, and he's convinced that they're gonna grant him immunity.
Well,
He's
even if
convinced they are.
they,
And if he does, if they do grant him immunity with a 5-4 vote, the Jack Smith's done, both in Florida and in Washington. He's done.
but isn't he, they don't even have to go that far. How long did it take them to get to the Colorado case? Not very long at all.
Right.
And when did they make the decision? The day before the Colorado primary. So
Right.
they are aware of what's going on in the world of politics. And how long did it take them to decide to take the immunity case? 2 weeks. And they didn't take it in December when Jack Smith wanted them to. How long? Oral argument's not till April 22nd.
Right.
This case is briefed within an inch of its life in the DC circuit. You have a well-respected decision from the DC circuit that, you know, they got all the information they need. They don't have to wait till April 22nd to hear an oral argument. And then they can wait till the last day in June to issue a decision if they want to. And Jack Smith is done.
He's done as far as scheduling the case, as far as checking scheduling the case.
Yeah, and if Trump wins,
right. But if I don't think Trump's going to win personally.
well, I can't imagine that he will. I can't.
Right. But if he is, I still think that the possibility exists that they're going to come out at the end of the term, which is at the end of June or end of July or sometime.
June, end of June.
Okay, with the 5-4 decision saying that he is immune from presidential acts and that these are presidential acts. I can see that happening with these people, and Jack Smith would be done as far as the prosecution goes.
Yeah.
But then Trump could lose the election, which means he could just keep going on ranting and raving about everything until he dies because he can't be held accountable for anything that he ever does.
Or the alternative they could do is to say that we need more information about which acts are within the scope of his presidential authority and which are not, and send it back for findings, which then delays it forever. But yeah, I don't, maybe you're right. I hope not.
I hope not too, but I'm not confident. I have more confidence in the electorate not electing Trump than I do in those 5 justices. And I would think it would probably be 5-4 with Barrett. Well, with the women against the men. I think it
Yeah,
would be
that's right.
the
Which
women
tells you
against the men.
something, huh?
Tells me everything. Tells me all I need to know. Okay. Um, Before we get to the final question, I'm going to go on to this thing that we talked about earlier. While the first 2 issues discuss major questions, historical analog, that deal with the concepts of SCOTUS ideologues made up to help promoting their radical agenda, the most egregious example of creating issues that don't exist come from a Colorado woman, Lori Smith, who filed a suit claiming she is damaged as a wedding website creator when she wasn't a wedding website creator. Her claim was that her free speech and religious rights were violated by the possibility of a gay couple requesting her to design a wedding webpage. But no gay couple made said request to a wedding website service that also didn't exist. Frivolous lawsuits are filed all the time and are generally dismissed by lower courts, but this claim of non-existent damage not only made it all the way to the top, it was actually decided by a 6-3 vote that a wedding website designer who really didn't design wedding websites had her rights to exercise free speech and religion violated by a gay couple that didn't even exist. How it got to the Supremes is an interesting backstory. There is an anti-discrimination law in Colorado as well as in many states. The Alliance Defending Freedom is a group that seeks out plaintiffs to challenge issues it wants SCOTUS to rule on. Since Trump and McConnell so successfully stacked it, don't you think that you have to be a damaged party in order to have legal justification for standing to make a claim that the law damages you? So what am I missing? Judy, you cited a case earlier about how somebody was, didn't really do that. I think it was
It was the
power
West
plant.
Virginia case.
Yeah,
Yeah,
the
power case. They're very similar.
Yeah, right.
There's
So what
no,
about standing? They just make up standing, or standing doesn't have to exist for just.
well, there's no case of controversy because in both of those cases we just mentioned, nothing's going on. Why is this case being litigated? You have advisory opinions, or you should have. And standing's another requirement, which has often been very strictly enforced. Environmental groups, there's a Sierra Club case. Environmental groups have had a terrible time finding plaintiffs with standing so that they would be able to proceed in court. So you have to be injured in fact. It has to be caused by the defendant, and it should be able to be redressed by the court action. But injury in fact, I mean, how is Lori Smith injured? And
Her sensibilities were injured.
Yes, I know. But mostly it's that Alito, not one of Trump's appointees, but I think Alito is intent on sort of promoting religion over any other consideration. So here, if you have a non-existent case, but it's her religious beliefs that are being damaged somehow, even though they're not.
We need to put an adjective in front of Christian religious beliefs.
I'm sorry, absolutely,
Yes.
absolutely. And so that's Alito's thing, and that they've done this more than once. If you think about the Washington, the Bremerton, Kennedy v. Bremerton. He was the football coach that prayed in the 50-yard line.
Mm-hmm.
And you know that any high school kid felt compelled to go pray with him. And he did it right after a game. But no, that was upheld. He can do that. So I think Laurie Smith's case rests more on just their just strong intention to promote Christianity, make this a Christian nation, which it was not founded as a Christian nation. But who believes that anymore?
Well, they want us to become one.
Yeah.
Yeah. All right, last question. I didn't send this to you, but I'm going to ask it anyway. Can this republic survive the corrupt power on display every time this court makes a decision? Are we in danger of losing our republic based on what this court does?
Well, I think not. The court is making itself prime. We talked about the unitary executive, I don't know, whatever, that the executive branch was so important. The court is making itself very important. So when you started to ask that question, I'm thinking, well, I'm not sure they can do it by themselves. But if you put the court, the MAGA Republicans, which aren't going to go away even if Trump loses, all those people in charge, I'm kind of in the camp that we're losing a lot of important freedoms, and whether democracy survives, I hope so, but
is the court complicit in the losing of these freedoms?
Yeah, I think so. I think they're a major part of it.
Yeah.
I don't know that they are doing it alone, but everybody's in on it.
Well, they have lots of help with Leonard Leo too. Leonard Leo's.
Yeah. Well, they owe their existence to him.
Yeah. I want to thank you so much. It was a great discussion. Whenever I dream about more things to complain about as far as the legal system, we're going to revisit you and go at this again. Is that okay?
I guess so, Paul.
All right. And all you out there listening in Cyberland, thanks for listening.
They can be fired from their jobs, so they don't need to say